In Lawless World, Philippe Sands argues that the Bush administration has defied international law in their execution of the War on Terror. This recent talk is an hour 20 minutes.
Good afternoon, and welcome to the University of California's Hastings College of the Law in San Francisco. My name is Andy Green. As Scholarly Programs Editor of the Hastings International and Comparative Law Review, I'd like to offer a warm welcome to the Hastings faculty, alumni, students, and distinguished guests. Also, let me extend a special welcome to those joining us on C-SPAN Book TV. We at the Hastings International and Comparative Law Review are excited and honored that the distinguished London attorney, author, and professor of law, Philippe Sands, is here at UC Hastings to deliver the third Rudolph B. Schlesinger Memorial Lecture on International and Comparative Law. Immediately following the lecture, we invite you to join Professor Sands and the entire membership of the Law Review in the Sky Room here at Hastings for a reception. Professor Sands will be signing his book, Lawless World, America and the Making and Breaking of Global Rules. For those of you who are here practicing attorneys for continuing legal education credit, please remember to sign in at the table outside. And now, without further ado, I'd like to invite Hastings Academic Dean Shauna Marshall to say a few words about the man we honor with this lecture.
Good afternoon and a warm welcome to everyone. It is really wonderful to see so many of you here with us for what is going to be a fascinating lecture. And a special thank you to all of you from Hickler for this wonderful, wonderful event. This is our third annual Rudolph Schlesinger Lecture. And I think it's only fitting to begin by telling you a little bit about my former colleague, Rudy Schlesinger. He joined the Hastings faculty in 1975 as part of our historic 65 Club. He was known around the halls as Rudy, but he was a renowned international scholar, a revered teacher, and truly an active member of the Hastings community. He was born in Munich. He graduated summa cum laude with a law degree from the University of Munich. Before immigrating to the United States, he worked as in-house counsel for a bank in Germany during the rise of the Nazi Party. There, he helped German Jews liquidate their assets and transfer their proceeds. He arrived in the United States and enrolled in Columbia University's law school. He was the first non-native English speaker to serve as editor-in-chief of the prestigious Columbia Law Review. After clerking and serving a little time in private practice, he joined the academy, where he became one of the world's leading scholars in comparative international law. Here, he taught comparative law and conflicts of law, and he helped found the journal that is putting on this presentation today. Let me tell you a few things that my colleagues have said about Rudy Schlesinger. Professor McCall said, "We were all charmed by his personality and yet awed by his brilliance." And another international scholar, Professor Mattei, said, "Rudy was an amazing combination of heart and intellect." So we honor his memory today with this lecture. And the vitality of his spirit will surely come to life today as we hear from Philippe Sands. I will now turn the podium over to Professor Paul, our very own renowned international and constitutional scholar. He will introduce to you Professor Sands. And very much like Rudy, Professor Paul is a wonderful teacher, a warm colleague, and an important contributor to our Hastings community. Professor Paul.
Thank you very much, Dean. It gives me a great deal of pleasure to see so many of our students here today to welcome my good friend Philippe Sands. Philippe is, as many of you know, a professor at the University College of London. We have an exchange program with the University College of London, and maybe some of you will have a chance to study with him through the exchange program. Previously, he also taught at New York University Law School and Boston College Law School, Cambridge University, King's College, and the School of Oriental and African Studies. Apparently, he has some trouble keeping a job. But Philippe has been one of the most prolific people in the field, particularly of international environmental law, as well as international law. He was one of the first people to really write about international environmental law. His book, The Greening of International Law, is a classic. And he was the founder of the Foundation for International Environmental Law and Development in London, which is also one of our exchange partners. As a barrister, Philippe has been one of the leading voices in the United Kingdom for the defense of international human rights and environmental law. He represented the British detainees at Guantanamo Bay. He has had a number of cases before the World Court. He's also was involved in the efforts to extradite General Pinochet to face justice in Spain. He's a regular contributor to both the BBC, British television and radio, as well as CNN. And most recently, he is the publisher of this book, Lawless World, which tells really the, I think, tragic story, the history of the last 30 years of American and British foreign relations, and the retreat that the British and the Americans have had from their strong commitment to international law and international institutions. His book has caused some controversy in the United Kingdom, as some of you may know. One of the revelations in his book, I don't think I'm spoiling your punchline, one of the revelations in the book is the fact that the British Prime Minister was perhaps less than truthful in discussing the reasons for going to war in Iraq. And that, in the book, he presents evidence of some documents by which the British Prime Minister purportedly ordered the Attorney General to change his advice in order to authorize the invasion of Iraq. When this came out prior to the elections in Britain, according to the Labour Party, it cost the Labour Party some 30 seats in Parliament. It should only happen to us. So I welcome his contribution to the ongoing debate in this country about the legitimacy of the war. And without further ado, please welcome my good friend, Philippe Sands.
Thank you very much for that very generous introduction, Dean Marshall, Professor Paul, faculty members at the University of California, Hastings College of Law, students and other friends and colleagues who are in the audience this evening. I hadn't known all the details about the background of Rudy Schlesinger, but in terms of what I'm going to say today and what I'm going to talk about, I think it's entirely fitting and appropriate to honor his memory and his contribution in putting the focus on the importance of the rule of law. I feel terribly privileged to have been given this lecture. It's my second visit to Hastings. I'm delighted that my own law school, University College London, in the heart of London, has a continuing relationship with Hastings, and I very much hope that will continue and that I will see some of you visit in London. The subject that I'm going to speak about is the question of America's engagement with international law. And I'm going to focus on certain, but not all, issues of legality and criminality which have arisen in the context of the so-called war on terror after 9/11, and in particular in relation to the war in Iraq. When I was invited to give this lecture a few months back, issues of legality in Iraq were, as Professor Paul has said, very much in the air in the United Kingdom. The May 2005 general election was dominated by a single issue, and that was Iraq. And it was dominated in particular by the question of the circumstances in which the British Prime Minister had committed Britain to war. Lawless World was published very shortly before the election, in February, in the UK edition, and as Professor Paul has said, it described the way in which the British government, in my view, misled both Parliament and the British public on the question of intelligence relating to weapons of mass destruction, as well as the content of the legal advice that had been given by the Attorney General a few days earlier. The revised and extended edition of Lawless World, which has been published this week in the United States, has been, I think, rather accidentally well-timed. Last Friday, as you know, Special Prosecutor Patrick Fitzgerald announced an indictment against Louis Libby comprising 5 charges. 5 charges against the Vice President's Chief of Staff. The circumstances touch directly on the way in which President Bush committed this country to war in Iraq, and in particular, the question of the reasonableness of the belief of the administration that Saddam Hussein's Iraq had weapons of mass destruction. The door is now a little more open, perhaps, to a comprehensive examination of that issue in this country. And indeed, just before I came today, I noted that there is a secret session going on in the Senate right now on that question. So the issue seems set to run on. In the case of the indictment of Mr. Libby, aside from the issue of the naming of Valerie Plame, I think it's clear to me that the road to war in Iraq is one which is tainted massively with international illegality. The conduct of the so-called war on terror, a term that is, in my view, wholly misconceived and which is not used in the United Kingdom, Tony Blair will not use that expression for reasons that I'll come back to, has caused the Bush administration to abandon wholesale parts of the very rules of international law that the United States has done more than any country to put in place. The Bush administration has done so as part of a strategy. It has acted deliberately and it has acted systematically. It has sought to create a legal black hole at Guantanamo, and it has sought to deny the applicability of the Geneva Conventions on the treatment of prisoners of war associated with the Taliban regime and also al-Qaeda detainees. It has done so also in a deliberate policy of detainee interrogations that has sought to avoid the constraints of the 1984 Convention on the prohibition of torture. And I pause there and note that the gentleman who has been named yesterday as the successor to Mr. Libby is widely considered to be the architect of that policy. The administration has done so also in terms of waging what is, in my view, an illegal war against Iraq, which was not authorized by the UN Security Council and was not justified or even claimed to be justified as self-defense. And it has acted in this way in a failure also to meet its international obligations in pursuing the policies known as extraordinary rendition, basically sending people to other countries where they can be tortured or abused. All of this is totally un-American. We face a very real threat from people who seek to do genuine harm to us. I have no illusions about that. But the systematic dismemberment of the rules of international law is an attempt which has backfired significantly. It has undermined the morale of American troops, it has undermined the morale of the country, and it has also undermined relations with allies in fighting against what is, as I said, a very real threat. It has also exposed, I think, the individuals associated with this policy to the very real possibility of criminal liability. How has this happened, and what's to be done about it? Before turning to these issues, let me provide something by way of background. The story that I'm telling begins in August 1941 on a warship off the coast of Newfoundland at a meeting between US President Franklin Delano Roosevelt and British Prime Minister Winston Churchill. This was a time of very great challenge for Britain and for the United States, incomparable with what we face now. And yet these two men decide that what they really need to do is draw up a blueprint for the new international order once the Nazis have been vanquished. What is needed, they conclude, is a new rules-based system to replace the then existing arrangements that allowed a state basically to do whatever it wanted, so long as it was not expressly prohibited by international law. And since not much was prohibited at that time, in the 1930s and the 1940s, there was a great deal that states could do. They could wage war without restriction. They could commit genocide against their own populations. They could torture detainees, and this was the wonderful world of the 1930s that Churchill and Roosevelt sought to change. They drafted a single-page document, the Atlantic Charter, by which they intended to be made known, as they put it, certain common principles in the national policies of their respective countries on which they based their hopes for a better future for the world. The Atlantic Charter was a short and visionary document which identified 8 principles revolving around 3 key pillars reflected in international law today. First, a general obligation on states to refrain from the use of force except in self-defense or where the UN Security Council or a regional body had authorized them to use force. Second, a commitment to promote the dignity of the human individual, modern human rights law, to maintain the inherent dignity and the equal and inalienable rights of all members of the human family, all members. And an undertaking to promote economic liberalization was the third pillar, through the adoption of free trade rules and subsequently related international obligations, for example, in the field of foreign investment protection law and intellectual property rights. These are the 3 pillars that have remained in place for the last 60 years, but overarching them was a commitment to the rule of law. What Roosevelt and Churchill did was commit themselves to recasting the 8 principles of the Atlantic Charter into a series of binding international legal instruments. And this they did with later assistance from subsequent presidents and prime ministers, including Truman, Eisenhower, and Attlee. There was cross-party support in Britain and in the United States for this change. In a remarkable period between 1941 and a decade or so later, the modern system of international law was put in place through a series of far-reaching treaties, which have now received very broad international acceptance. In the spring of 1945, 51 states agreed on the creation of the United Nations here in San Francisco, crystallizing in law the modern rules governing the use of force and promoting human rights. That was followed by the UN General Assembly's Universal Declaration on Human Rights, Eleanor Roosevelt's baby, it's frequently called, which in turn led to the covenants on civil and political rights and on economic and social rights, as well as regional agreements like the European Convention on Human Rights and, in Britain, the Human Rights Act of 1998, the closest that we've got to a written constitution in the United Kingdom. The very day after the Universal Declaration was adopted, the General Assembly agreed on the world's first human rights treaty, the 1948 Convention on the Prohibition of Genocide. And that's been followed by other specialized human rights treaties, including the 1984 Torture Convention, an instrument of singular importance, which obliged all of its parties to prosecute or extradite torturers and those who were complicit in carrying out torture. And it was that instrument, of course, which did away with Senator Pinochet's rights to claim immunity from the English courts in 1998. By then also, in the mid-1940s, the Allies, as they were known, had agreed on other new rules to stop individuals doing particularly unpleasant things to each other. The statute of the Nuremberg Military Tribunal gave birth to a new field of international criminal law, and this would eventually lead directly to the Yugoslav and Rwanda tribunals, and then also in 1998 to the Statute of the International Criminal Court. And in that same post-war period, the US and Britain led international efforts to negotiate the 4 Geneva Conventions on the laws of armed conflict, including the now notorious Geneva Convention No. 3 on the treatment of prisoners of war. This, of course, is the very same instrument that is to become the center of so much attention in relation to events in the past 3 years at Guantanamo, in Afghanistan, at Abu Ghraib, and in other parts of Iraq. Developments in international law were no less far-reaching in the economic field. The Bretton Woods agreements created the World Bank and the International Monetary Fund in 1944, and in 1948, agreement was reached on the General Agreement on Tariffs and Trade, the GATT, the world's first global free trade rules and the parent of today's World Trade Organization, the WTO, that many of you in this room will have studied. By any standard, these were truly remarkable achievements in a very short period of time. The new rules-based system initiated by the Atlantic Charter was not altruism at play. It reflected a view that international rules would promote Anglo-American interests and values and serve as a bulwark against the Soviet model and emphasize values to be marshaled against the Nazi and other fascist threats. But the simple point I make is that international rules were seen as creating opportunities, not as imposing constraints. The Atlantic Charter had an immediate and far-reaching impact. Writing in his autobiography, which no doubt many of you will have read, Nelson Mandela describes the Atlantic Charter as reaffirming his faith in human dignity. Some in the West, he writes, saw the Charter as empty promises, but not those of us in Africa. Inspired by the Atlantic Charter and the fight of the Allies against tyranny and aggression, the ANC created its own charter, which called for full citizenship for all Africans, the right to buy land, and the repeal of all discriminating legislation. Over the next 60 years, the principles set forth in the Atlantic Charter defined a new international order. A great number of international agreements have been adopted since then, and they touch on issues that affect each and every one of us very directly. Trade, investment, commerce, air transport, telecommunications, oceans, boundaries, human rights. The great majority of these rules are not controversial in any way at all. They work efficiently and they work well, and we all benefit from them. But they only establish minimum standards, the minimum standards necessary for cooperation in an increasingly independent and interdependent world. The emergence of this body of rules reflects a silent global revolution, and most people are blissfully unaware quite how much international law there is and how it works. I accept entirely that this raises serious issues about accountability and legitimacy in international lawmaking. It's a matter of real concern that in some countries, such as the United Kingdom, treaties are generally not debated by Parliament, unless, of course, they address issues of European Community law. That's not the case in the United States, and it's one of the reasons the United States takes its time often to ratify these treaties, a factor which I think the United States cannot be criticized for, actually quite the opposite. By all accounts, in the United Kingdom and in other places, there was simply no debate at all about the agreement establishing the WTO. That was not the case here. That issue is not for this afternoon. I wouldn't also wish to leave you with the impression that I'm starry-eyed about international law or international rules, or somehow to suggest that global rules can sort out the many wrongs of the world and the many problems that the world faces. Plainly, they cannot. Events over the last 60 years demonstrate that there are a great number of issues which international law has not been able to address, and that there are a great number of rules which plainly require attention. And certainly, we have to accept that the world has changed very greatly in the 60 or so years since the United Nations was created. The sheer number of states has grown from 50 to 200, a result of decolonization. The range of issues requiring international cooperation, and hence international legislation, has also grown to include new modern issues like the environment, tourism, consumer safety. New international actors have emerged. The monopoly of states has diminished, and international organizations, NGOs, corporations, individuals are all demanding an increased role in ways that present profound challenges for an international legal order which has been constructed on the assumption that the global order revolved around states alone. Failed states, peripatetic travelers, permeable national borders, malign non-governmental organizations like Al-Qaeda and other terrorist groups, and the proliferation of the possibility of weapons of mass destruction are but some of the issues that pose very real challenges to the established international legal order. Do they require us, however, to revisit the basis of the post-Second World War legal settlement? President Bush has made that argument, and so has the British Prime Minister, which in some way provides support for President Bush's approach. So are the existing rules adequate? That question has been asked with increasing frequency since 9/11. It is said by some in this country that the international legal order is no longer up to the task it was designed to address in the period after the Second World War, in the face of these current challenges. It is said that the rules governing terrorism, wars, and rogue states are somehow inadequate. And some go even further. They say that the international rules and international law threatens American security and American sovereignty. To be sure, those who make this claim most frequently and loudly are often associated with a neoconservative element that has dominated the agenda of George W. Bush's first administration. We won't speculate as to who that was, ringing in. Even in the months before 9/11, it had become abundantly clear that President Bush's administration was committed to remaking the international rules, and even to limiting or killing off the rules that were seen to be too constraining on American power. Many members of the group in the administration had been in office in the first Bush presidency, and in fact some also date back to the Reagan presidencies, and they regrouped during President Clinton's administration. Plans were set out in various manifestos, and I commend to you in particular one whose authors include Messrs. Rumsfeld, Cheney, and Wolfowitz. It is the statement of principles of the Project for a New American Century, and that gives you, I think, a very real flavour for what was being proposed and what was being cooked up in the late 1990s. Tapping on a rich vein of American exceptionalism, their key targets include international law and the rules which had allowed, for example, the detention of Senator Pinochet, the statute of the new International Criminal Court, the Kyoto Protocol on global warming, and various arms controls agreements. Each of these treaties would, it was argued by these individuals, constrain America, undermine sovereignty, and even threaten US national security. Within weeks of taking office in January 2001, President Bush had set a new agenda. Kyoto and the ICC were unsigned, a protocol on biological weapons was scuppered, and a new policy of so-called a la carte multilateralism was put in place. You just pick and choose the bits of international law you like and get rid of the rest. John Bolton was appointed as one of President Bush's senior foreign policy advisors, as Undersecretary for Arms Control and International Security at the US Department of State. That, of course, is the same John Bolton who is now the US ambassador to the United Nations. It was he who would oversee Iran's compliance with its nuclear obligations under the Treaty on Non-Proliferation of Nuclear Weapons. But this is the same John Bolton who had said just a little earlier that treaties were only political and were not legally binding. Very early on, significantly, as we shall see, a small group of neocon ideological lawyers were parachuted into key positions at the Justice Department and as consultants to the Pentagon and the Department of Defense. Although their views were not widely shared, especially amongst career civil servants and military lawyers, they would come to dominate decision-making in a critical period after 9/11. The point I'm making is a simple one. Even before 9/11, the conditions were in place for an assault on the Roosevelt's vision of international order based on rules. And from this perspective, it is my view that 9/11 presented a terrific opportunity to promote the international, anti-international law project. Little time was lost. Within days of the attacks on the World Trade Center and the Pentagon, lawyers in the Bush administration had been charged with putting in place new legal rules which were necessary to prosecute the response. On the key legal issues, there was no consultation at all with any of the United States' allies, some of whom, of course, such as the United Kingdom and Spain, have very direct experience of terrorist attacks of this kind. And I say particularly in the case of the United Kingdom, where we have long-standing experience in relation to the IRA. A very early decision was taken to characterize the response to al-Qaeda and international terrorism as a war on terror. This, I think, has been wholly misconceived for a number of reasons, but not least because what you do by using that phrase is you elevate criminals into the status of warriors. But this, of course, also had the effect of taking it outside the scope of the ordinary criminal law, which is what they intended to do, and into the rules of armed conflict. And there they faced their first roadblock. The rules of international law placed limits on what you could do to detainees. POWs couldn't be questioned. acting unilaterally in a manner that was wholly inconsistent with the requirement of the Geneva Conventions, the administration determined that individual detainees would be placed entirely outside the constraints of the law. The Guantanamo detention facility on land leased from Cuba was chosen precisely because administration lawyers had advised that its location outside the United States would provide a means of would avoid the possibility of redress under US constitutional law and also under international law. Guantanamo was created as a legal black hole, as the English Court of Appeal described it.